Thank you. Let's dive right in. So we'll be talking about courts and the Constitution in the context of our work. And may I begin by asking each of the panelists to describe the main theme or the main argument that underpins your book or your work more generally on the functioning of the Indian judiciary. Thank you.
Shall I use this one? Yeah. Thanks. So just briefly, my book is called Unsealed Covers, and it covers the last 10 years of the relationship between the courts, which is in our case often the Supreme Court, the Constitution, and the state. It's a collection of essays, most of which were written as immediate responses to various constitutional events, cases, happenings in the courts. And it now looks back on those essays and tries to curate them by theme, important themes. For example, the UAPA and its impact on personal liberty and how the courts have understood that. The major claim that I make in the book is that the Constitution is a terrain of contestation between different ideas of power, and the courts are direct players in that contestation, for good and for ill. So just to give you one example, in the UAPA section, which is this anti-terror law in India, on the one hand, you have various cases that try to give a narrow reading to the law and insist on actually establishing certain facts before people can be denied bail, on the one hand. And on the other hand, you have other courts, other judges, sometimes the same judge, who actually go and defer to the state and deny bail and keep people in prison for long years without trial. And at any given time, both these visions of the Constitution, personal liberty, law, and the state are in tension. And each case is the court intervening in that. And I think over the years, if you see, you'll see where the patterns go, and that's the attempt of the book. So I'll close with that and hand over to.
Thanks, Gautam. My book, as she said, is on caste. The title is Caste's Pride, Battles for Equality in Hindu India. So let me clarify that when I use the word pride, I do not in the least suggest that it is something that one ought to take pride in. The devil lies in the details, as they say. There's a lot of stuff in my book about the legal history of a little explored area, that is the system of caste from a legal lens. There's a lot of new material relating to judicial and legislative debates going back 2 centuries, dealing with different legal reforms of caste. But since the topic of this is on courts and constitution, let me focus on the mass violence aspect and the impunity that followed. The first major instance of mass violence targeting Dalits took place in 1968 in a place called Kilvenmani, and we had the Madras High Court holding that the accused who were arraigned before the trial court were all rich people owning vast tracts of land. Some of them even own cars. So they were unlikely to be part of this mob that allegedly was responsible for burning alive 42 Dalits, women and children. They were all burnt alive in one tiny room. So this was a kind of classist view that the Madras High Court took. And that incident set the pattern for mass violence and also for impunity. And in the course of my own work as a journalist, I dealt with instances in, say, Bihar, where an upper caste militia called Ranveer Sena was responsible for a series of massacres. And Batani Tola was the first, and then followed Lakshmanpur Bate, which was considered the biggest ever instance. Some 58 people were killed, and that led to a trial court convicting as many as 26 people, 16 of who were given death penalty. That's the highest ever in any single case. And yet when the same matter went before the Patna High Court, every one of them, without exception, on the flimsiest of grounds, was exonerated. So my book explores this kind of impunity that persists, this structural impunity, where it is coming from, That's why I felt the need to go into that legal history of caste, the system of caste. There are also instances where convictions have been made because of the wealth of evidence that is there and the gravity of the offense. But then the courts would go out of their way to deny the caste angle. One glaring example is Khairlanji, which took place in this very century. And as recently as in 2019, the Supreme Court had occasion to deal with that case. And there are seven references to one of the girls who was killed in that case, in that particular instance, Priyanka Botmange. She was found stark naked. And this is something that fits into, what is generally the pattern of caste atrocities, that it's, it's very much part of their intention to humiliate Dalits by stripping naked Dalit girls. Now, the Supreme Court refers to Priyanka as many as 7 times, but not once does it mention this vital detail that her body was found naked, because that would have then made it harder for them to deny the caste angle to that atrocity. So there are many such issues that this book explores. I think I already overshot my time, so I hand over the mic to Sudhir.
Yeah, I think we can use both mics just to be quicker. So I'm going to follow on Aparna's initial suggestion that we have a hagiographic style of responding to the courts, and I'm going to qualify that point in saying that it's usually the lawyers and judges who have a hagiographic style where they might celebrate the court as the greatest institution and so on and so forth. But in academic and public criticism, it's more like what Manoj just described, or anyone who's seen Gautam's book might pick up, which is that we have a very vibrant critical tradition of responding to our court. In fact, that tradition can be so strident that at the turn of this century, we are suddenly floundering because we reckon seriously with the possibility that the center will not hold, the constitutional structure may not hold. And then the question of what is appropriate criticism of our institutions, what is the value of our institutions, whether that be parliament or whether that be the courts, takes on a very different relief. It takes on a different perspective. And I'm very interested in trying to develop and explore a method and a way of thinking and talking about the court that is institution preserving, and talking about parliament in ways that is institution preserving. And I don't know that this is a strong instinct in our culture, and not one that is apparent in the center spreads of most newspapers, which then makes the question more urgent and specific. And so much of my work in recent times has focused on this question, and this is how I come to the topic for today. Aparna.
Thank you. Yeah. And my own work, my own book, which is Courts on Trial, takes a quantitative look at the working of the Supreme Court. And we argue that some of the roles that were envisaged, and the multiple roles that were envisaged for the Supreme Court, have been stymied because of the institutional structure and the administrative processes of the court, which allows for the court to either be captured or to be allowed to be used in many of the problematic ways, its power to be used in service of many of the problematic ways that the previous speakers have identified. So its ability to enforce legal liability and constitutional norms is limited by backlogs and delays that the court has brought on itself, and that allows the court to evade responsibility for, evade its own responsibility in deciding cases, sensitive cases in a timely manner. Gautam's written on that in his own book. It's hampered by opaque administrative processes, which place a significant amount of power in the hands, and unaccountable power in the hands of the Chief Justice. by an appointments process that is shrouded in mystery, and by a process of admitting new cases that privileges the most expensive and the most powerful lawyers and allows them to bring and admit very weak cases before the court, and leads to a range of other knock-on effects in the working of the court. So, and the large argument that we are making is that without paying attention to the institutional structure and the administrative processes, the back-end administrative processes of the court, we cannot hope to have a responsive and accountable judiciary. So that's my book. Let me turn the conversation back to our panelists and then ask them then the broad question of reflecting upon the relationship between the courts and questions of justice and injustice, again, based on the kind of work that you've done. Sudhir has posited that there is space for preserving these institutions as spaces where justice is possible, the account that Gautam and Manoj posit is that courts have had a history, by no means a given, but have had a history of using their power in service of injustice. So the question is there space for the courts to be preserved as spaces where we put in a lot of our energies in dealing with questions of justice or injustice, or should we look beyond?
Yeah, I think that the question of justice and injustice is inseparable from the question of power and who has power, who wields power, and upon whom is power wielded. And I think if you look at the history of the courts, what comes out is subject to a few exceptions, and that's where the space is preserved. There has been a great deference that the courts have shown to one kind of power, which is a centralized, concentrated vision of power that primarily rests in the executive at the center, as opposed to a more plural, distributed, decentralized version of power. So I'll take one example to perhaps make the point. So Article 20, Clause 3 of the Indian Constitution is the classic right against self-incrimination. So the idea that if you're accused of an offense, you should not be compelled to incriminate yourself, because often when you are in the police station, that balance of power between you and the police is so skewed that the Constitution must step in and create some safeguards to preserve your integrity, your autonomy, and place some restrictions in what the state can do in its pursuit of what it believes to be the truth. And if you look at the history of the interpretation of this provision, what comes across is a deep suspicion on the parts of the courts when it comes to giving this its full play. So for example, the clause says that no person accused of an offense will be compelled to be a witness against himself. The question of what counts as an accused is itself a controversial question. And what the courts have said, for example, is that actually if the law which is being used against you is not a criminal law in formal terms, say a socio-economic law, and the people who are going after you are not police officers defined as police officers, then you're not an accused. Even though these people have all the coercive powers of the state to wield against you, even though they keep you in custody and they interrogate you, still you don't have that right. And the example of this in most recent times is the ED. Right? So the ED, which I'm sure all of you know of, basically if the ED comes after you and interrogates you, you don't have the right under the Constitution to not incriminate yourself, because the courts have said that they are not police officers, even though they behave like police officers, and you're not arrested and accused, even though there is no difference between you and an actual accused under criminal law. And that's one example. And if you look at the entire domain of constitutional law, federalism, constitutional pluralism, different kinds of arrangements, rights, other institutions, the people, and so on each axis you will find that the courts, by and large, have tended to favor this centralizing statist view of the Constitution over a more distributed view of power and an egalitarian view. And where I think the space comes in, and I'll close with this, is that you will find this countercurrent, this sort of submerged interpretation as well, that takes the other view. I think trying to advocate for that and trying to bring that to the forefront is a space where the courts, I think, have an important function, and where we as people who engage with the courts have an important function.
The example that Gautam cited of ED's powers being upheld despite all sorts of problems being there. It's the ED officers being not just police but also judicial powers they have, right? So compared to that, we are all familiar with the monstrosity that was upheld by the Supreme Court not too long ago. But when it comes to issues of how justice is denied to marginalized section, we tend to overlook that. Now, the example I cited of Kilven money is, proves my point. The Supreme Court delivered its verdict on this case, which took place way back in '68, and the High Court judgment came in '72, '73. But the Supreme Court delivered its judgment in 1990. By then, there was also a legislative acknowledgement of, atrocities requiring a more stringent law. There was this Prevention of Atrocities law that was enacted by '89. But even then, when the Supreme Court finally delivers its judgment on the first big atrocity that took place in the country, first recorded instance of mass violence, all it does is it delivers a 4-page judgment in 1990 saying that we see no reason, we examined the case thoroughly, and we see no reason to interfere with the finding of the High Court that there's no case made out against any of the accused. That's all. We don't know anything about why no case is made out, why the accused deserved to be let off. We know nothing about it. So the point I'm making is that there's too little transparency, even if the judgment came very late. I mean, lack of responsiveness is one problem, and then lack of transparency is another problem. And another example that comes to me of that is, there's this famous case of Belchi. It's famous to the generation that lived in 70s. It's a case where Indira Gandhi famously reached that remote place on top of an elephant, and it's supposed to have been the beginning of her comeback trail. But what we do not know is that some years later, that was the only instance where a killer of Dalits was finally hanged. This is the only instance of a killer of Dalits being given death sentence and that death sentence being executed. This is as counterintuitive as, say, a white supremacist in America being executed for killing blacks. And yet we know nothing about it. I had to move heaven and earth to lay my hands on this judgment. Why? Because this amazing example, this singular instance of death sentence being given to killers of Dalits was never recorded in any journal. No law journal had it. And there's a death penalty project in National Law University. There's a team of academics working on it, and I urged them also to help me in that search, and they too couldn't find it. I had to move heaven and earth to finally lay my hands on it. So that's the kind of odds we are faced against, and it's an example of how unresponsive and how non-transparent our system is.
So we have very little time. So let me just make 2 points about the courts and justice relationship. The first is that we tend to personalize courts and treat them as if they were an analysis of persons rather than of institutions. We recognize in a sober moment that we're looking at assemblies of persons and complex practices and processes that produce results, but we tend to very quickly personalize those results. And my first instinct about the way we do analysis and Supreme Court analysis is to depersonalize and to focus on institutional outcomes rather than sharply personal accounts of why justice or injustice is produced or not in particular cases. The second intuition that I'd like to focus on and explore is that we tend to have very strong perfectionist ideas of justice that somehow institutions are supposed to achieve in everyday life. This is an unrealistic view of collective politics, democratic politics, or judicial politics. And if we keep railing against this perfectionist assumption, the chances are that we run through the ground on which these institutions sit. These are imperfect institutions. They will produce wrong results on many days, and hopefully they produce more right results than not. And that is the best that we can hope. And setting reasonable expectations in public institutional life is critical. The third is some expectation of linearity. Whether it is on the caste question or any other moral question of the day, any reasonable account of the last 70 years of the Supreme Court will show a checkered history. We go backwards and forwards, and in some iterative way, we do get ahead. And this constant refrain, which is to take every decision that somehow doesn't fit a linear narrative as some, the latest outrage that we should all be trashing the institution about, is something that we must seriously guard against in public life. And my sense, I'm speaking in generic terms and not about specific cases, but it's this kind of mode of criticism and appreciation that we must cultivate as a critical citizenry to have half a chance at constitutional preservation.
Thank you. There's so much to unpack in that conversation, and I think a question of methods as well. But let me just close by asking each of you, in the spirit of having a less imperfect institution, if you could recommend one court reform, what would be your highest priority? And let's go the opposite way, and I'll have the last word then.
So I'm the one resisting magic bullets on this panel, so I'll leave it to my panelists to sketch this.
A less imperfect one, so it doesn't have to be magic bullet.
If you can repeat the prompt.
So, what would be your top priority for court reform if you had to have one court reform method?
So let me just work off the initial statement you made, Aparna, that the question of court legitimacy is going to turn on composition. And unless this issue of appointment is reasonably resolved, and by this I don't mean that the executive government of the day has the last word, but reasonably resolved, I don't see a strong court surviving into the middle of the century.
Yeah, to the point that Sudhir made about greater transparency in appointments, I would add the point of greater accountability as well. So much that happens within that space, and we know a little about it. We tend to be too hagiographic, too reverential, and there's also this question of interference from the executive, and all that is brushed under carpet. So all this comes under the broad rubric of lack of accountability, and that suits, what is dangerous about it is this lack of accountability in the judicial space suits the interests of the executive, and that's not in our interests at all, the interests of the people at large.
I think that public coverage that focuses more on the reasoning of the court, the internal reasoning, and not on the outcomes, I think is something we need to cultivate.
Okay, and for me, it would be that the court should not be able to evade its responsibility to decide the most crucial constitutional questions of the moment, and so structural reform that, for example, creates a permanent constitution division or a constitution bench, so that the court cannot say that that we are going to take 6 years to decide something as crucial to Indian democracy as the electoral bonds case. On that note, we'll bring this panel to an end. We are already over time. Thank you, everyone. Thank you to the audience for being here, and thank you to the panelists.